never survive merely because the provisions of Article 56, Subarticle 1 of the Constitution of Zambia, as amended in 2016 and refined through the Constitution of Zambia Amendment Act number 13 of 2025, have been held. Democracy will only be said to have survived if those elections are actually conducted in a manner that spells transparency, a manner that spells accountability, a manner that ensures that elections are conducted in a free and fair atmosphere that does not involve violence and intimidation. Now, the question then is posed: where do we derive our prosecutorial power? It is my submission that prosecutorial power is firmly grounded in the Constitution. Under Article 1, Clause 1 of the Constitution of Zambia, as amended from time to time, particularly in 2016 and most recently in 2025, the Constitution of Zambia, since independence in 1964, has come up with a provision that is so unique. Unique in the sense that at independence in 1973, in 1991, in 1996, and until 2016, all we knew when we talk of supremacy of the Constitution was that, it's a supreme law of the land, that any written law, customary practice, and customary law that is inconsistent with the Constitution is void to the extent of its inconsistency. But you see, as at 5th of January 2016, the people of Zambia decided otherwise. They said, no, we've lived with this one for too long. The Constitution went further in Article 1, Clause 2, to actually indicate now, for the very first time, the same of which has remained obtaining to date, to the effect that now, any act or omission that actually contravenes the Constitution is not only inconsistent and null and void, but it is illegal. It is now illegal. So, whatever it is that we are going to do as prosecutors, come that second Thursday of August of our year 2026, it must be intra vires the Constitution. That is what we should remember as prosecutors. In Clause 3 of Article 1, the people of Zambia decided that through the supreme law of the land, we should remember also that all of us, every person in the Republic, every state organ in the Republic, and indeed every institution is actually bound by the Constitution. So, to us as prosecutors, the lesson we get from this, from the lens of the electoral process, dispute resolutions, is that every single electoral process and system in this Republic must be intra vires the Constitution, failing which it is illegal. Secondly, as we prosecute those that decide to transgress our electoral laws, we should know to say we must do so in accordance with the rule of law. Democratic elections. Zambia, as a constitutional democracy, has since 24th of October 1964 been a constitutional democracy. But now, under the current constitutional order, we know under Article 45 of the Constitution that you see the Constitution itself recognizes our democratic practices. We are told when we read Article 45 together with Article 46 and Article 47 that the Constitution envisages that our elections must be free and fair, they must be transparent. We should not actually choose leaders because we've been, in a way, influenced in an undue manner. So that is what we should follow, because that is what the law envisages. Further, in Article 45, Clause 2, particularly Paragraph 5, the Constitution tells us, because we recognize the fact that it is inevitable. In every competitive, democratically contested election, it is inevitable that ultimately electoral disputes will arise. But then what should happen? We can never blame the fact that we've got electoral disputes. They should be there, and they're expected to be there. That is what competition brings about. But the Constitution says in Article 45, Clause 2, particularly paragraph E of the Constitution of Zambia, you see, there must be timely resolution of electoral disputes. Now, Article 45 alone in the Constitution is not the only one actually that mandates or obliges us to ensure that there is speedy adjudication of matters that actually ultimately we prosecute and they end up in court. Because the same is also found in Article 118, Clause 2 of the Constitution. So the desire ultimately of the people of Zambia is to ensure that when you get to court to have your matter resolved, when you get to court to at least have your day in court, can that be done in a very timely manner? More so when it is something to do with matters hinging on electoral processes. Because people want to know the results like yesterday. What is the decision of the court? The matter that was prosecuted, how did it end? We've been hearing here from Honorable Luweji, if my memory serves me right, I'm not very good at names, that these things happen on the ground. They do happen. We are not here to think of who are we going to blame. If something happened in the past, ours, post this gathering, is to look at, we've got 13th of August 2026 coming our way, there will be competition, and should instances of that nature happen, what are we going to do as electoral process dispute resolution stakeholders? What are we supposed to do to better ourselves as a country in a manner that will actually ensure that the will of the people has been met? Colleagues, the electoral administration in this country is also constitutionally grounded. Our election managers in this country, pursuant to Article 229 of the Constitution of Zambia, as amended in 2016, and as I always call it, and I prefer to call it that way, refined electoral process-wise through the Constitution of Zambia Amendment Act number 13 of 2025, is the Electoral Commission of Zambia, the Commission. These are our managers that ensure that the elections that we desire, the elections that actually prompt us to have to meet in this manner, actually are conducted in a manner that is free and fair, in a manner that is accountable to the people of Zambia, in a manner that actually spells that the will of the people has truly been achieved. Now, to us as prosecutors, it is my submission that it is very important that stakeholder engagement, particularly with law enforcement agencies and the Electoral Commission of Zambia, be made even stronger. Stronger because you can have the best performing prosecutor in the country. But if you have got a very poor investigation from the law enforcement officer that investigated the matter, you can never win a case. Because you'll be dealing with very, very bad witnesses. That will give you very bad evidence. You've got little to do when you are before the court. You can have a court that actually is so attentive to the evidence that is being presented before it. But if there is nothing, you cannot actually fish from a pond where there is no fish. There's nothing, you can't catch fish. So it is important that we have stronger electoral justice coordination amongst the stakeholders. The most common offenses that are electoral related, we will find them in sections 81 through to 91 of the Electoral Process Act, others call it number 35 of 2016, which I'm acutely informed now has become chapter 13 of the laws of Zambia. So they are there. They will include bribery, they will include intimidation of voters, they will include defacing of electoral materials. So when one is caught up, one has decided to go against the law, we have learned from previous speakers that the law is there. Ours is to find it where we are, where it is, and also to present it in a manner that will actually ensure that those that willfully transgress, they are brought to book. But the problem is there. Article 45(2)(e) tells us, resolve them quickly. Article sections 81 to 95 tell us, these are the offenses. Yes, we are aware. But as prosecutors, how do we ensure that we've got this speedy adjudication? Because for all I know, apart from matters really that have something to do with the economic and financial crimes, we do not have legislation or legal provisions that actually dictate how and within what period criminal matters are to be actually processed. We don't have. So we are told to say where a piece of legislation that actually provides for penal sanctions for particular prescribed conduct does not stipulate the procedure to be followed when prosecuting such matters, then in section 3 of the Criminal Procedure Code, chapter 88 of the laws of Zambia, we fall back on the Criminal Procedure Code. Now, you can skim through, run through the Criminal Procedure Code. There is nowhere where we will find a provision that tells you to say electoral-related matters, conclude them within this period of time. It doesn't exist. What then do we do? Do we fold our arms and say, look, there is no law, so what do we do? When the Constitution wants us to speedily adjudicate, the answer is no. We are privileged and blessed as a nation because since the year 2008 to date, I'm aware that we've been running as prosecutors, we've been running together as judiciaries, as judicial siblings. I call ourselves siblings in the dispensation of justice with the cooperation, the communication, cooperation, and coordination initiative, CCCI. So we can actually engage in CCCI to ensure that these matters of an electoral process nature, we actually dispense them off speedily. At the moment, pursuant to the electoral process revision of Wards Order 2021, is the statutory instrument number 57 of 2021. Zambia has a total of 1,858 wards. In those wards, colleagues, my distinguished prosecutors, those are your areas, our catchment areas, where the ad hoc local government election tribunals, where the aggregates. Because it is from those 1,858 wards that the people of Zambia on the 13th of August 2016 will actually be electing political leaders at the grassroots level we call councillors. Very, very important, our local government elections, because we are the closest interface between the citizen and the state. So those are potential hotspots, and we don't end there. We have in the country a total of 116 districts. In those districts, we have political election competition at mayoral level as well as council chairperson level. So when you add 1,858 for councillors, 1,116 in the districts shared amongst our mayors as well as council chairpersons, we have a total of 1,974 contestable areas. And you can have actually 1,974 charge sheets. Because if you have criminal activities taking place in all these areas where we are existing as local government election tribunals, then we know that we will, through the Office of the Director of Public Prosecutions, ourselves, the office from which under Article 180 we derive our authority, we will have work to do. And the people of Zambia have indicated, we heard from one of the victims of such, that they want results. And results, as we know it, will not always result in convictions. They will result into acquittals as well, because that's our duty. We don't have a duty to ensure that there is a conviction at all costs. Ours is to ensure that those that have committed the crimes, those that have truly committed the crimes, are convicted. And that those that are alleged wrongly to have committed the crimes are actually set free. They must be restored to their liberty. That's what we do. Allow me Just a little latitude, learned Director of Public Prosecution, to digress a bit, because when I come to this point, this is home. The members that make us gather here, these distinguished prosecutors, I know that amongst them, the majority of them are legal practitioners. When it comes to the resolution of local government elections, under Article 159, Sub-Article 1, particularly paragraphs A and B, the Constitution mandates the Chief Justice to actually establish such number of ad hoc local government election tribunals to determine whether an individual has been validly elected as a councillor. Further, they also have a mandate to actually determine whether the office of councillor has fallen vacant. But then who are these people that constitute the ad hoc local government election tribunals from which, or for which the Chief Justice can constitute into ad hoc local government election tribunals? In Article 159, Sub-Article 2, we are told that that tribunal will be actually presided over by a magistrate of competent jurisdiction, but this magistrate will sit together with two legal practitioners. The law, the Constitution in Article 159(2) does not discriminate to say because one is a prosecutor, they can't sit. So I'll be lobbying to the learned Director of Public Prosecution through this forum at Mulungushi, and I'll remember it's the 18th of March, that time when it comes post the 18th of August, that you permit us to tap into the wisdom, competence, and intellect of my siblings gathered here. They will be part of the local government election tribunals that will actually resolve. And because of that, when we gather and look at prosecutors, we always view them from one lens. We always view them in tandem with Article 180, criminal prosecutions. No. These, they guard our democracy even from a civil lens by being members of our ad hoc local government election tribunals. Because of the double lens from which we view them, it is my submission that it is not correct to actually simply regard Zambia's prosecutors gathered here as sentinels of democracy. Instead, they are correctly and truly supposed to be called unique sentinels of democracy. I thank you.
Thank you so much, Your Honor. We'll have our second speaker, who's a distinguished scholar, as I earlier stated. Our second speaker is Ms. Mutinta Chilufya. For over 10 years, she has stood in our courtrooms prosecuting complex criminal cases. Today, she leads prosecutors across Southern Province, guiding law enforcement, advising on justice issues, making sure that the guilty are held to account. But her work doesn't stop there. She has served on election tribunals in Central and Luapula provinces, helping to settle disputes that could have shaken communities. She has studied legislative drafting in Zambia and international criminal justice in London. Currently, she's pursuing 2 master's degrees while showing up in court every day. The law is her life. Justice is her business. Please welcome to the podium Principal State Advocate in the National Prosecution Authority, Ms. Mutinta Malu Chilufya. A round of applause, ladies and gentlemen.
Good morning, learned DPP, distinguished ladies and gentlemen. You know, the beauty of coming on the last day or presenting on the last day of such a power-packed conference is you get to stand on a very solid foundation that has been laid by the previous speakers. And to an extent, you would almost say that everything that I wanted to say has already been said. But the DPP won't agree to that. And just by way of reminder, our theme is unique prosecutors, or as it's been put now, prosecutors as unique sentinels of democracy, ensuring inclusivity, electoral integrity, and the rule of law. Now, how do we go about capacitating these sentinels of democracy? How do we build capacity, not just in the prosecutors, but also in the systems within which they operate, so that they are able to detect, monitor, and adequately respond to the threats and the changes that may arise within the local government elections. As Honorable Mwinga has already highlighted, we are on the ground. When you talk about local government elections, you are talking about the communities within which we operate, the districts where we are. It's not something that's foreign to us. I'll not look at the legal framework that has already been talked about. I'll just start by talking about recognizing the challenges in the different stages of the electoral government, local government election process. And it's important to note that public trust in democracy, the rule of law, integrity of the government and electoral process is essential to public safety. And as a prosecutor, there's a duty to protect the integrity of the electoral process in order to safeguard that public safety. Now, as a sentinel, you need to know, to monitor, to be able to detect. You need to understand what are the challenges that you will face. You cannot deal with something that you do not understand. So we can move to the next slide. So there are different stages, actually, to the electoral process. But for the purpose of this presentation, we'll just stick to three, or we'll classify them into three. So we have the months prior to the elections, where we are now. We have the period during the elections. Short as it may be, it is very critical and is actually the purpose for which we are here. And after the elections, what are the challenges that we face? From the start of this conference, we've heard about the many challenges that are faced during these different stages of the electoral process. So in the months prior to the elections, we see a lot of violence, we see a lot of misinformation, we see a lot of things happening, okay? And to state that the level of violence is uniform throughout the country will not be true. There are different zones and there are different characteristics in every different part of the country. During elections, obviously, we see all that we've seen prior now heightened and at its worst, okay? So it's very important that as a prosecutor, you are well aware of the unique challenges within the domain of where you're operating. We can move. The role of the prosecutor has been highlighted throughout this particular conference. The common thread is the need to protect the integrity of the electoral process. This is very vital because the peace of this country depends on it. And how do we do that? We ensure compliance with the electoral laws, and we address the electoral offenses in a fair and impartial manner, okay? And we address the criminal conduct affecting the election outcomes. So this is from the very beginning, from the stages that we've talked about previously. This is what is on our mind, and this is what we are attempting to achieve. We can move to the next slide. Now, what is it that, how should we posture ourselves as prosecutors? We've talked about the prosecutor and the systems. What that tells you is, as a prosecutor, there's a mind you should have as you are looking at electoral issues. The systems may be there, but what is the mind that you're supposed to have as a prosecutor? So the posture of the prosecutor is such that you should ensure there's confidence from the public that you are acting for the right reasons based on facts and the law. The previous presentation talked about a non-partisan stance, and I was grateful for Mr. Simusa, who came out to talk about the fact that prosecutors should always bear in mind that their stance should be non-partisan. That is at an individual level. Is there a system that supports that? That's the question. Do we have that system? The systems are there. We've talked about the Constitution, which provides for independence and upholding of public interest. So there's nothing in the system that says a prosecutor cannot be neutral. We are well supported. At an international level, we have the UN ODC guidelines on the role of prosecutors. And bringing it home, as the National Prosecution Authority, we have the Prosecutors Manual and the Code of Conduct. The institution has equipped us as prosecutors to proceed in a non-partisan and neutral manner. When you look at the guiding principles of a prosecutor under the Prosecutors Manual, next slide, please. A prosecutor is told that in the performance of their functions, they should uphold the Constitution, respect human dignity, human rights, and the rule of law, adhere to the NPA core values, which are integrity, independence, fairness, transparency, and accountability. Follow the code of conduct to act objectively and impartially, avoiding discrimination of any kind. Might I add, avoiding political discrimination of any kind. Now, when we look at the system that has been put in place, it therefore assures us that we are supported to be non-partisan. Now, how do you move as a non-partisan person? Firstly, being a citizen, we know that we have political preferences, obviously. It begins with an intentional detachment of our personal political inclinations from the decision-making process. This is quite vital. So prosecutors, as we've already highlighted, should perform their duties independently, impartially, and without political influence. Political influence coming from within yourselves as a person, because we know that we all have political inclinations. Political influence from within the place that we operate, within the districts where we are, and also not to put ourselves in situations where we are going to be politically influenced. That's very important. Avoiding decisions, ensuring that decisions are evidence-based, avoiding perception of political favoritism. You do recall in the speech by the DPP that it was mentioned that impartiality should not just be done, but it should be seen to be done. And if there's one thing that's quite evident to see, is favoritism. We should ensure that in all our conduct, there's no political favoritism that appears to be there. We need to protect the credibility of the justice system. These are issues that have been highlighted throughout this presentation, throughout the conference, and I think that I'm here just repeating and reminding ourselves of what we're supposed to do. What are the strategies and the best practices? We have talked about building capacity for the prosecutor to handle election offenses. So how best can they do this? We've learned from Kenya what they have been doing. We have also been advised by the other speakers on how best we can proceed with capacitating our prosecutors. We need strategy, obviously, and we need to develop best practices in this regard. We move to IT, the other slide. Okay, I'll proceed. It appears IT is having a challenge. So we talked about how we've segmented the stages in the electoral process. So we have the months prior to the elections. What do? We need to educate the prosecution team on the important election information, the offenses. This is part of education. And I believe that as we go back, we'll be changed in how we will look at these particular offenses. We've been told about developing guidelines on the prosecution of electoral offenses. We need to have focal point persons to monitor in the different places the electoral process as it is going. What's the violence like if there are places where there's violence? How best can interventions be made? Building and strengthening relationships with key stakeholders. We have the courts, we have the law enforcement agencies, we have other partners whom we should work with in order to ensure that we are responsive in this electoral year. Would consider establishing an interagency team if necessary. We have already the CCCI. That's an avenue that can be used, as Honorable Mwinga had indicated. Call for prosecutor-led investigations to speed up the process of investigating electoral offenses. We have noted that most electoral offenses sometimes do happen in a crowd. And the challenge that we find as prosecutors is that everyone is bundled together by law enforcement. The victims, the witnesses, the accused persons. And by the time the docket may be coming to us and we start sorting, there will be an issue of credibility of witnesses. So where we put in place prosecutor-led investigations, as Ms. Mumba had indicated on Monday, it helps to ensure that the process is speedy. We've already been told we should be swift in how we prosecute these matters. There's need to develop strategies on how to protect witnesses. When you put this together with prosecutor-led investigations, it will be easier to protect witnesses because we'll be there firsthand to know who are the witnesses and what interventions we should put in order to protect them. We need to engage the courts for speedy or expedited hearings or the need for in-camera hearings. This calls for good relationships with the courts. I believe that Honorable Mwinga has given us quite a good foundation on what the expectations of the court are as we are proceeding in this particular year. Now, sentinels should not just be reactive. There's need for us to be proactive. We need to educate the public on the electoral offenses, their duties and responsibility as citizens. We already have quite a bit of social interaction as the National Prosecution Authority through our social handles, Facebook, X, Instagram. Those are avenues to educate the public on what is expected of them. What are the electoral offenses? And what is our role? We can use those avenues to affirm our commitment to just elections and also to the fact that we'll be impartial throughout the process. We've heard how children are used during elections. Visit schools, talk to the children, educate them on what is expected of them during this election year. Build public confidence by having a non-partisan stance as a prosecutor. And here is where conduct matters. We've heard about soft skills. If you recall on Monday, Her Ladyship Justice Kawimbe talked about our conduct in court. Imagine prosecuting a matter. Maybe there was an assault at a rally. And as you're walking in, you just pass a comment. What is the perception there? You've not started prosecuting the matter yet. It was just a comment. But how far does it go? What's the perception that is created? So those are some of the soft skills that we need to work on. We should also be aware that as prosecutors, we are subjects of extensive scrutiny in the communities within which we work. So we need to ensure that there are certain places we shouldn't be found. There are certain things that we cannot do, just in order to preserve the public image. There have been talks about not having sufficient data in relation to electoral offenses. And in addition, that we as a country may not have had sight of certain information. But it would be important to put data to zone areas where do we expect to have a lot of violence and what will be the responses that we'll put in place. IT has decided to just put the conclusion, but I'll proceed. I don't know what they're trying to tell me. The data is quite important because then data tells a story. And with the right story in the right hands of decision makers, it gives us a way forward. And as prosecutors, we get to know how we'll proceed and what interventions should be made. Now, during the elections, you cannot skip the interventions that have been talked about, this capacity, and try to perfect everything during the elections. As we've been told, election day is just one day. And of course, a few days after that, when announcement of the results and so forth. However, that is the most critical part. It's as if you are preparing for an operation. The operation may be a few hours, but how you prepare for it will determine whether you live or die. So with the proper foundation being laid, with the months prior, what will be some of the things we should look out for as prosecutors to ensure we should ensure expedited hearings of the electoral offences so that we do not disadvantage any of the candidates and that the matters are quickly disposed of. Making use of the social media handles, Learned DPP, would be essential to updating the public on what is happening with the cases that are already heard in the public realm. Now, after the elections, what do? Do we wait for the next 5 years? No. We actively develop a database, statistics of the electoral offenses. What is it? Where is it happening? How do we respond? What lessons have been learned? Post-analysis, help develop a standard operating procedure for prosecution of electoral offenses. This is quite important. And unlike the guidelines, this will now give us in-depth information from the experiences that would have had on what needs to be done. And obviously, we begin to plan for the next election cycle, because this time around, as sentinels, will be geared with the right information, the correct statistics, and more able to respond to whatever changes may come our way. We go to that quote. I just thought, as a way of ending this presentation, we're reminded of the influence we have as prosecutors. We might say that the power of prosecutors is the ability to cause outcomes through influence. Most of the time, we think that the only thing we cause are outcomes, but we forget those outcomes don't just become. They are because of our influence. And may we commit to ensuring that this particular year, the influence that we have, we ensure that we have inclusivity and we have the rule of law in this particular electoral year. Thank you so much.
Thank you so much to our distinguished scholars. We get to a very interesting segment where we need to interact with our distinguished speakers on this very interesting topic. I will invite comments. I can see the hand of Honorable Mono Luvezi. Ushers, kindly help us with the microphone. We'll take a set of 3 questions, so please raise your hands for those that want to interact.
Thank you so much, and I would like to thank the 2 speakers for their insightful discourse. In my presentation, I talked about abuse of incumbents, and I would want you to clear the myth that how do I put it? Okay. NPA and Zambia police, your duties are relative. You are in the courts to prosecute. They are the arresting officers. They bring to court. And then I talked about abuse of incumbents in the elections. Abuse of incumbents, I can give you an example. I'll give an example of a Livingston case of murder of a PF cadre, and then the police, they were very quick to arrest everybody who was in Livingston, top leadership, starting from the current president, the MPs who were in Livingston, provincial officials, district, anything red, they were picking. And then immediately they took them to police. I even said, this case in the courts of law, it's a BID. Because how possible that the president, Honorable Nkombo, Honorable Leti Muntanga, everybody, all of us, we killed one cadre. So I said, this case, even before it takes off in the courts of law, it's a BID. My question to you is, how will you take out this myth that actually is the abuse of incumbency? That's why you as NPA, you fail to prosecute these cases. You fail to bring witnesses. You failed in Livingston to bring witnesses to say, yes, we saw this UPND leadership killing this cadre. Thank you.
We'll take 2 more questions. Comments, questions, recommendations? Two more before we invite the speakers to respond. I see a hand to my right.
Good afternoon. Mrs. Joyce Luawa, Director Legal, Kitwe City Council. It's more of a recommendation than a question. Honorable Mwinga did mention that there will be consideration for all the prosecutors to be, or advocates to be considered to sit on the local government elections tribunal. My plea is that it should not be limited to NPA alone, but it should cut across to the local government and any external prosecutors and advocates. Thank you.
I'll allow the speakers to respond.
Thank you so much. Before we attempt to answer the question on abuse of incumbency, may I throw it to the DPP? Then we can see how we take it on.
Well, I'll not talk about historical issues in the National Prosecution Authority. We may have had issues, however, there's no case that the institution can fail to prosecute. As Madam Tinta ably presented, we have a prosecutor's manual that guides the work that we do. We also have a code of conduct that also guides what we do. So anyone who commits a crime and the case is investigated and we are sure that we have a bankable case to take before the court, we shall do so. I'm unable to explain why people failed to do so in the past. And clearly, we have a special working relationship with the police. The example that you referenced, the Livingstone case, clearly there was something wrong on the side of investigations. And perhaps that explains why the prosecution could not proceed to court. And without even being so privy to the intricacies of that case, it could be the case that prosecution advised investigation that this is not a matter we can take to court. And this is why it has never seen the light of day. So there are a lot of processes that go on behind closed doors. And prosecution takes a lot of interest in interfacing with police to guide them, to advise them. When we think that a case, there are no merits, there's no evidence that will stand the light of scrutiny in court, that case will never proceed to court. It will never proceed to court. I know when people are looking from the outside, it would seem as though prosecution is biased, or there are certain considerations that are being applied. For us, as long as the thresholds are met, we have scaled the evidential test, the public interest test, that matter is going to court, irrespective of who the accused person is. Things may have worked differently in the past, but of course it will be difficult for me to explain. Safe to say that there's no case that NPA can fail to prosecute. And it doesn't matter whoever the accused person is. But also we have to be guided by our procedures and our prosecutor's manual. I don't know if I've covered all the bases on that one. I could have left out something.
Thank you, Leonard DPP. It's covered everything.
Thank you so much. There was a recommendation. We'll just ask Honorable Mwinga to comment on the recommendation that has been made.
Anytime I'm given an opportunity to stand, I stand, because most of my work involves sitting. My sibling from Kitwe City Council, my other siblings from my other mothers, from my other departments or institutions in our great republic, there is no cause to worry. Like I indicated when we interacted, Article 159, Sub-Article 2 of our Republican Constitution does not discriminate. When the question arises as to who will be part of the ad hoc local government election tribunals constituted by the Honorable the Chief Justice under Article 159, Clause 1, Paragraphs 1A and B, the question is, are you a legal practitioner? If the answer is yes, you are like any other of my other siblings in the National Prosecution Authority, at the Legal Aid Board, at the Ministry of Justice, and even those that are in private practice. You have an equal role to play. I am aware that in 2016, led DPP, we had across the country 50 local government election petitions. Because of the same, when we were preparing for the post-2021 local government election petitions, we thought capacitating in electoral process, particularly as regards electoral dispute resolution, 31 legal practitioners was enough. We were very shocked after the 12th of August 2021 general elections that we received a total of 272 local government election petitions, which currently under Article 154, Sub-Article 4 of the Constitution as amended in 2025, must be heard and determined. It was very, very stressful, but I'm grateful through this forum. May I say thank you very much to those of us that took part in that role. A number of them, the Leonard DPP, they came from the NPA. And that's why I'm not shy to always knock, and I know judiciary will again knock, not only at your door, but the other siblings, including Kitwe City Council. I'm obliged.
Thank you so much. More comments, questions, recommendations? I can see a hand to my right. Is that correct? Interesting. Ms. Chilufya, you had talked about a prosecutor avoiding the perception of bias or favoritism, especially in this crucial period that we're heading to. I would like you to just talk more on it. You specifically mentioned about a prosecutor avoiding certain places to avoid the perception of bias. Please come through.
Thank you so much. Bias is something that we see, and it's something that should be avoided as prosecutors. As I had indicated, during this period, we're under a lot of scrutiny wherever we are. I believe we know the concept of local knowledge within the police circles. Basically, when you move to a new place, you check the area around. Where is the police? Where is the hospital? Where are the crucial areas that you need to know? The same intensity with which we check around these areas, sometimes the same intensity with which the members of the community look at us. The investigators, they know our preferences, what we want to do, or where we like to be. Now, imagine you're at a rally wearing a particular shirt for a particular party, cheering, maybe I even refer to as chairman and things like that. And on a Tuesday in the week, you are the one prosecuting someone who was assaulted, either from the party you were, for the party of the shirt you were wearing, or something in that nature. What would be the perception? You would not have said anything, but you would have created a bias. The other side will automatically believe that the conviction was because of chairman. Chairman is a prosecutor, and therefore that's how everyone is at NPA. So basically, when you talk about bias and how we can avoid it, look at the soft skills. Mr. Kemo had talked about soft skills. How best do we deal with such situations? What are the soft skills that we need to activate and ensure that we observe even as we go through this period? Sometimes it's just the comments that we pass, as I had indicated in the presentation, the places we go to. Of course, that does not mean that we should just live in isolation. If you do recall Ms. Kauma's presentation, Ms. Kauma, the Vice President of the Law Association of Zambia, encouraged us to know what is happening around us. But even as we do that, we need to be mindful of who we are and what we represent. Thank you.
I was hoping you would touch on Facebook comments. I think it's common for prosecutors to use the digital world, to use the digital space, especially Facebook. WhatsApp is not so much because obviously it has a limited audience. But perhaps I would like you to talk more also on Facebook comments, on various pages. What role does the prosecutor have, especially with this period that we're going to?
Thank you so much. What I've already said extends even to our social media presence as prosecutors. I know sometimes we hide behind some names that we may not know, but it is important that we remember the noble profession by which we are called, even on social media. We should not hide behind certain positions that they will not know me. You know, there are funny names on Facebook. You don't know who it is. But let us remember that there's a picture that is being portrayed to the public, which matters and which is very important. Not that we should not now go on Facebook and interact on the social space, but we need to be mindful that we are prosecutors, and there's a picture that is being presented to members of the public. And once they see us in court, after the whole weekend, you are busy posting very interesting or funny things on the Facebook page, the bias would have been created. And if there's something that is difficult to dismantle once created, is negative bias. We are ambassadors of this institution as NPA, but more importantly, we are ambassadors of the ethics of the prosecution fraternity. So it is important that we are always mindful of who we are.
Thank you so much. We'll take on more questions, comments, recommendations. Thank you. Can see a hand? Ushers, please help us. Honorable Bezi's hand is up. Please, you may proceed.
Thank you so much for the second time. My questions are more on the elections, because I'm a politician. ECZ, they usually have a committee at the council. What do they call that? The one which mitigates...
the Conflict Management Committee.
Conflict Management Committee. And I take it you are members of that committee. I take it you are members at the council level. You are members of that committee. Okay, it is fine. I'll proceed with my question. Whether you are members of that, if you are not members of that committee, wouldn't you recommend that you be members of that committee, because you find all the cases at the end of the day that you prosecute, they start from that committee. If you are members of that committee, the way that committee operates, Because at the end of the day, whatever goes on in that committee, somehow it still sees itself in the courts of law. So, if you are members of that committee, what other things would you recommend to be done on that committee? Because that committee actually fuels up the tensions during elections. Thank you.
Thank you so much, ma'am. As we had indicated, that's a very good observation, and I think it's something that we'll take on to be members of those committees, and more importantly, to educate the committees on the offenses and how best they can also educate the members, their members and people on the ground on what is expected of them during the election process. I cannot speak for the committee. I don't know how their activities are, but I think one thing that they do is to go in the communities to talk to members of the public, and being part of that committee would allow us to have that kind of audience. Honorable Mwinga.
Honorable, thank you very much for that insightful observation. But I tend to think, I'm not sure at the present moment whether the Electoral Commission of Zambia's district conflict management committees are particularly prescribed in their Act of Parliament that establishes the commission. But I'm thinking, if that be the position such that we would be offending if, as prosecutors, we joined, there is still an avenue, because the way we've been working, ultimately what we are looking at is the cause of justice, all of us. So how we've been operating is through institutional coordination, through the communication, cooperation, and coordination initiative. So I think if we went through that way, and for my colleagues, the prosecutors, if we have prosecutor-led investigations, because most of the cases that come before court, they actually collapse owing to inadequate investigations. You will have really excellent prosecutor before you. But if they don't have an investigator who did their very best to dig up the evidence, theirs is simply to lay it, and for me as an adjudicator, it's too simply to reduce it into writing. But I'm thinking, if the prosecutors are there, as we are preparing for the day, we are there in the districts, in the constituencies, where political contestation is going to take place on the 13th of August 2026. We should have that information on our fingertips, even the investigators themselves, because we are the ones that actually lead the evidence. We are able to guide, to say, look, proceed in this manner. Then when it is ultimately brought to court, it will be very easy to lay it before court, and it will be flowing, and the court will have a basis to make a decision. I submit.
Any interventions? I can see a hand on my far right.
Good afternoon. My name is Amitej Mulenga Mumbwari from SACOD. I'm a member of DVEC. I just want to guide that it is very true that DVEC is a recognized part of electoral management, and the idea is for arbitration. It is not there to establish criminality or any other serious offenses. Political parties are members of the committee. PF is a member of that committee. UPND is a member of that committee. Citizen First is a member of that committee. So the idea is to have resolutions done there amicably. When matters are criminal in nature, cases are referred to the police and the investigations are supported. So to guide, the purpose of the DVEC, the purpose of Conflict Management Committee is to ensure that we reduce the number of cases that go to court. Because after all, we are Zambians, we live in the same community, we can resolve our issues before we escalate them to the courts. So ideally, DVEC and the District Conflict Management Committee are supposed to work together to ensure that we don't overload the courts with the criminal cases in relation to elections. Thank you.
Thank you so much. I saw another hand. Any interventions from my right? Okay, I can see a hand on my far left.
Okay, Isaac Muhongo is my name from Manyinga. My question again is directed to Honorable Mwinga. I think in the year 2024, we saw some massive or mass recruitment of legal officers in the local government. And I think almost all district councils had a fair share of legal officers. Some entered as council advocates, while others were picked as senior legal assistants. This means councils now have what we have the advisory component when it comes to legal services. Yeah, now the question is, I know advocates, they have got their role, and senior legal assistants also, they have got the role to help those who are advocates in order for them to carry out their mandate. But the extent to which these legal minds are being utilized, to some point, you discover that there's some kind of underutilization, because a lawyer is a researcher, and a lawyer or who is in full practice or who is envisaging to achieve such a skill and knowledge in law should be a person whose mind is ever busy and made to research, unlike being limited to maybe the same nature of jobs or the same kind of, and this is in line with the advocate, the director from Kitwe. I'm sure you heard they are saying, to what extent are these legal minds being involved in issues that border on elections, certain things, they are even being championed by people who do not even know how to define what law is. Sorry to say so, but certain things may be peculiar to certain minds because of what is involved. So to what extent are these minds, now that they are all over and in almost all the jurisdictions of the local authority? Thank you so very much.
Thank you very much to my sibling from Manyinga. To what extent are these legal minds utilized? I will attempt to answer this purely as it relates to ad hoc local government election tribunals. Coming from the premise of our discussion under Article 1, Clause 2 of the Constitution, we interacted this morning to the effect that if we do anything, any act we undertake or a mission that we undertake as a people of this republic, and that act or mission contravenes the Constitution, actually we are trading into an illegality. It's illegal. So for purposes of ad hoc local government election tribunals having to assist us with resolving local government election disputes, the legal minds that would be called upon to form part of the local government election tribunals under Article 159, Clause 2 should be legal practitioners. And legal practitioners are those amongst our numbers who actually have been admitted to the legal bar, having satisfied the requirements of the Legal Practitioners Act, Chapter 30 of the laws of Zambia, and we have walked the path that we informally call Andrew Mwenya Road. Others call it 911 there in Rhodsburg. It's a very difficult path to walk along, 10 months of intensive intellectual feeding. So once one is admitted to the bar, they are truly a candidate to actually be called upon. Like I indicated earlier on, in 2021, we underestimated. We were thinking, 2016, we had 50. We were actually thinking we'll have a maximum of about 50. So we are looking at having about 30, 31 ad hoc local government election tribunals. But then we got a shock of our lives, and we don't want that kind of thing to repeat. So we are thinking if we had 272, this time we'll assume there might be 400 to 600. Then what would be the ideal number of tribunals to have? And truly, we look everywhere, and we know that in our places of work, we have other assignments. If it's my colleagues, they'll be prosecuting criminal cases. Some of them, from say Ministry of Justice, they'll be drawn into the petitions, the parliamentary petitions at parliamentary level. So we go to our leaders, like the Honorable the learned DPP, to request so that those that may actually be able to be given to us, we work together in that 30-day period in resolving local government election tribunals. So to that extent, I hope I've attempted to answer my sibling from Anying. Thank you.
We'll take on 3 interventions. To my right. I'll move to the left wing. Any interventions, recommendations? You've ably answered, and it's a commendation that the council, the local government, has employed more advocates. This is a core for utilization, because I think his question borders on underutilization of the legal minds that are available. So the fact that we have more advocates, I think it's a core to ensure that we have more of these advocates in the ad hoc tribunals. Any interventions? Thank you so much. This has been, I see a hand on my far right.
Sorry to intercept Honorable Mwinga. I think, again, I didn't introduce myself. Michael Nundo, NPA, Senior Public Prosecutor. The issue I can see from the local government, legal minds, is still popping. Should be second or third time. They really want to participate in those ad hocs. So, Honorable Mwinga, I don't know how you, with our office, would advise, because the issue is participation. Thank you.
Thank you very much, my sibling. We should be consoled. how we proceed in actually coming up with who is a member, judiciary does not just sit on its own and remember at Mulungushi I sat next to XYZ, so this person must be a member of an ad hoc local government tribunal. No. What we do, because legal practitioners are regulated by the Law Association of Zambia, and there's an act of parliament that regulates what goes on at LAS, we actually, prior to the elections, we are already working. The judiciary has what it calls the Bar Bench Liaison Committee for the Honorable the Chief Justice. So we interact with the Law Association of Zambia, where we have the members who are legal practitioners. So we actually indicate through the executive director there to say, look, we are requesting from your members that those that may be interested to take part in the local government in the resolution of local government electoral disputes, should we have petitions? It's anticipatory actually. So then please may you give us a list, because when time kicks in, the Constitution now in 159 clause 4 is couched in very mandatory terms that within 30 days, the local government election tribunal must actually hear and determine. This is what we decided as at 2025, 18th of December to be precise, through Act number 13 of 2025. So we receive the evidence and make the decision. 30 days begins running following the filing of the petition. So your subordinate courts to which the petitions are filed at local government level are actually 67 currently in the country, out of which 65 are fully operational. So now I get notified as coordinator, literally through WhatsApp. It will just come and it's 19 hours. An election petition has been filed. Where? At Chilubi. Then we begin running to now move the office of the Honorable the Chief Justice to have to establish. So if where we are coming from, it's our duty now, I will request that we go back to our leaders and we begin to whisper to say, should this opportunity arise, I'm available for such. And I must indicate that we really need to do more. We will need to have to begin reading, because as at present, statutory instrument number 60 of 2016, which is our local government electoral process rules, is being revised. And a number of things have changed. So we need actually to keep abreast with what the new rules will be. They are still sitting. We submitted very recently for finalization and further guidance before the learned Attorney General of the Republic. So we will have to acquaint ourselves with that. But can we begin to lobby? Because we can't paralyze government operations somewhere for a period of 30 days just for us to run as judiciary. But all of us in the country, all my siblings who are legal practitioners, we are welcome. But can we engage so that when we knock, when that time comes, we know that we are okay. And those of us that are not in government, if you are in private practice, please ensure that you are not only a legal practitioner, but that you are a legal practitioner, one, of good standing, and secondly, that you have your current practicing certificate for the year 2026. I submit.
Thank you so much. A big thank you to our speakers for doing justice to the topic. A round of applause for our speakers as they leave the podium. Ladies and gentlemen, we'll be having an early lunch. A few rules to take note of. We are breaking for lunch early, so we are expected to be back in the main auditorium at 13:50. We are expected to be back in the main auditorium at 13:50. Please, let's take note of time. We will allow the learned DPP and the high table to leave before we take our leave. Thank you. Our speakers for today, you follow the delegation with the DPP. Thank you so much. A reminder to our participants, you are encouraged to carry your bags because we will only be back after 18 hours. We'll be going straight, after lunch, we'll be going straight to the main auditorium. So you are encouraged to carry your laptops, your bags. Thank you.